Economic Regulation of Transport Amendment Bill. As you can see displayed there, that's the bill and that's the act that we're actually amending. And as we have said, this is a technical amendment. There are two things that we must deal with. First is in terms of Schedule 1. I would want, if members support the amendment there, to by loud speaking say, we support. And then if that's the case, we then move to the short title. Those are the two technical amendments that have been. I'm putting before you Schedule 1 to Economic Regulation of Transport for you to agree or not agree. Do you agree? Honorable Ghana.
Thanks very much, Chair. I agree, support the amendment for both the schedule and also the short title. Thanks.
Agree to both the schedule and the short title. Can I get a second now? Honorable Gopa?
Thank you, Chair. I second Honorable Ghana.
Can we all agree by show of saying yes that we all agree? Okay. We all agree. Is there a dissent? Honorable Answer.
Thank you, Chairperson. If I may refrain from a particular decision, since you're pushing for a particular decision,
Yeah.
not submitted this to caucus yet.
Okay.
So I just retain my right thing to react at a later stage.
You are not participating.
I'm not participating in this decision. If you'll allow me that space, please, Chair.
No, there's no problem. It's within your democratic right. It must be respected. Thanks very much. All in all, we have agreed. Done with this part, the report? We are agreeing to the bill, isn't it? We are all agreeing to the bill, except the fact that the Honorable Hong Singer would want to note that not at this point, no point at this point. Thank you very much. Mover for the bill. Can I get a mover? Honorable Montana moves.
Second, Chair.
Honorable Bloser, second. Honorable Ghana, second. Thanks very much. We are done with this aspect. Now this is the report. Can I get a mover for the report? This is the report that would obviously you would have read it. It outlines just what the process that unfolded for the amendment until we arrive here. Can I get a mover?
Yeah, it's a report, Chair. We'll move for the adoption of the report.
Thank you very much. Seconder?
Second, Chair.
Seconded. Thanks very much. The report is duly proposed for adoption and is duly adopted. Thanks very much. We are now done with the economic regulator of transport. So it will now be taken to the House, right? We are done in our part with this until we take it to the House. I'm correct, right?
Chair, the committee's process is done. There will be a second JTM process and the certification after that. It will be introduced for the House.
Okay. That's what I wanted to ascertain. In our part as a committee, we are done on this matter until we take it to the second step. And I must indicate that we are legally wise. We have our legal team here, which has just came to guard that we make sure that we do things right. On this part, I hope they are happy. I see them smiling. We're going to the second one, the merchant shipping bill. We have had a hearing, public hearing, as you may be aware. Today, the department is supposed to respond to those issues which were raised in the hearing, so that we can also then, after those responses, we follow up with them. But from there, we'll then have to determine ourselves as to what then becomes the next step in terms of public hearings, in terms of comments. We can excuse the ERT legal advisors. I think what we were here for was too quick and we are happy now. Thank you very much. The next step, the colleagues from the department, you are here. Yeah. Nicholas? Yeah, please.
Thank you, Honorable Chair, and good afternoon to all the members. And we thank the opportunity to come here and respond to the issues that were raised, both in written form and they are re-echoing during the public hearing that you held. And we would then be responding to those issues, and so they are grouped as per the entities that commented on them. So, in the first instance, then I'll start with explaining that legislation in this case aims to give meaning to the policy of government. And I think in this case, the underlying policy that informs us is the Comprehensive Maritime Transport Policy, which is an embodiment of the future structure and formulation of the South African maritime economy. The maritime sector is, as I think it's been recognized as one of the sectors that is lagging behind in terms of transformation. And the transformation of the maritime sector is slightly different from the traditional understanding of the of transformation, because it's a global industry, and it's an industry where there is no active participation of South Africa and the South Africans in that economy. Participation comes in two forms. One is that of consuming what the service provides. So there is an active participation in, as consumers of the services that we draw from the maritime sector, but there is no participation in the economy, in the structural economy of the maritime sector, and partly we're trying to deal with that in this bill. But in larger part, what we're trying to deal with is updating our maritime legislation to be at the level in which our desire to be an international maritime center by 2030 is achieved. And the mechanism of legislation helps us in progressing and making strides to achieve that status. So we have these comments, which I think follow as a result of a robust consultation that the department conducted in the making of this bill. And those extensive consultations, I think, gives us certainty that we did not leave anyone behind. And the bill that is before the committee now is a bill that has been enriched by those submissions that we received during the drafting stages. And even before we came here, the language and the constitutionality of the bill went through the standard testing which confirm that the bill, firstly, in its drafting style, and as well as its compliance with the Constitution, has been ensured. And that's why, therefore, a suggestion which challenges that is unfounded, because the bill gets certificated. We get an actual certificate from the Department of Justice and Constitutional Development, which confirms the style, and secondly, which confirms the constitutionality of what is being proposed. So any suggestion contrary to that is not founded unless it can then be tested. So and we deal with those issues then in 1, 2, 3, where we make the point that the suggestion, for instance, that the language of the bill is not transparent and that it does not go, that there are other ulterior motives in what has been drafted, I think is void of any truth, in that the language is very directive and very clear in its intentions, more especially on matters relating to its objective of domesticating the treaties, and secondly, in its objective of regulating cost-wise traffic. So the language, in our opinion, addresses those issues quite vigorously, and this is now been tested by the nature of submissions, which we have understood them to be very clear, where, for instance, there's an objection to coastal shipping, and which means that the message in the language was able to communicate clearly that we want to create opportunities for South Africans to participate in the maritime economy because of the need to address the issues of transformation. Then progressing to issues raised under Chapter 3, where there is a submission that the bill does not expressly reserve the movement of coastal cargo to South African ships. We addressed that by bringing the attention of the committee that where we have defined coastal cargo, we are removing any ambiguity, and we align that cargo with powers of the minister in prescribing such cargoes which will require to be moved through the permitting system that is being promoted by the bill. The intention is very clear in that only prescribed cargo will qualify as per definition. And the reason, for instance, that coastal cargo is unmentioned in section 63 to 69 is for a simple reason that that section is itself about the vessels to be permitted and ahead of the carriage of the prescribed cargoes. So as stated in the intention, it is not to confuse the definition of cargo and a vessel. And where we think the company raising these issues so must be clarified in that the licensing provisions have no relation to coastal shipping, because they have confused the issue of licensing. Licensing is just for non-commercial vessels, very small in size, which has always been there. It's present in the current Merchant Shipping Act, and they are not the licensing provisions which are for coastal shipping. But by including coastwise traffic in ships in the definition of a South African ship strengthens the transparent intention of restricting the carriage of cargoes in between ports of South Africa to coastal shipping permit. And yes, I think in section 14, forms part of that eligibility criteria that
So you just came to disrupt us? Just a minute. Huh? And is she supposed to be there? Huh? Okay.
page 3. So I would then, Chairperson, then move to for instance, clarifying that the decision of registration still remains with owners. So a ship owner will decide on which flag the ship wishes to register. But the South African Ship Registration Act, as it is at present, regards any ship that is owned by a South African to be entitled to be registered as a South African ship. And because the aim is to create opportunities for South Africans to participate in the coastal shipping market, by extension, therefore, those ships would be owned by South Africans, so they will be entitled to be registered. And that's why in the definition of a South African ship, we have roped in the coastal shipping vessels that would be used to move coastal cargoes. Then there are issues that Sassoa raised with regards to the lack of clarity, which is heightened by consideration of section which is referred to in the definition of coastal ship permitted vessel. And they also raised the issue that the meaning of the proposed legislation is simply not clear on the following reasons, and the reason that they highlight is they relate to that it's only South African ships that will be engaged in coastal shipping and coastal shipping vessels, which is in brackets cabotage, and we have provided such that intention is very clear that as it exists at the present moment, foreign ships come to any port in South Africa with the intention of offloading cargo that they have brought, but they as well collect cargoes in other ports before they sail ashore. Now, the recent practices are now extending to having warehouses established so that South African shippers, before their cargo is loaded on ships, it will be kept in a warehouse owned by a shipping line, which would then collect that cargo into a ship and moving to another port. So there is an absence of participation of South Africans in the maritime value chain, because even the agents that either ship agents and or any other agents, they do work to support the activities of these global companies that dominate the maritime value chain in South Africa. And transforming that is not something that the current dominating actors would welcome, because what it does, it creates an opportunity for the domestic shipping market to participate in the shipping value chain. And this is not unique to South Africa. A number of other countries are engaged in what is called, in other countries, is called short sea shipping. Europe has got short sea shipping, and other regions of the world, they do have short sea shipping. In the South African context, that opportunity does not exist for local players to participate because of how coastal shipping is regarded. And this bill aims to correct that imbalance, because it doesn't mean that the present arrangement makes, for instance, as an example of what is being raised here, that it makes the cost of movement of goods cheaper, and or in any manner it benefits South Africans to participate in the maritime economy. Moving also then, in paragraph 8 there, where SASOA believes that neither interpretation would pass constitutional muster. The first would amount to irrational and unworkable apparent restriction. And this is now on the language that we have used in the bill, and we have addressed this question and clearly disagree with the assertion that the intention of the bill and its provisions in the sections 13 and 14 are not clear enough to demonstrate the intention of government in creating opportunities for South Africans to participate in the local economy. Moving, I think, also down to clause 3.3, SASOA submitted that the provision is more problematic, where they suggest that unless otherwise indicate, those provisions of this Act which apply to vessels which are registered or licensed in the Republic, or which in terms of this Act are required to be so licensed, apply wherever such vessels may exist. And I think this is this is where that very same provision pertaining to the license of vessels is part of the present legislation, and we have not in any way amended that part, because it speaks to the licensing of vessels that are not engaged in commercial activities. 3.6, where SASOA submits that the phrase "except as otherwise prescribed" raises the question as to where or how that happens. And here, I think members will be aware where the use of the term "prescribed," it means that it will be by regulation by the minister, and we have articulated that well in clarifying that the minister would identify and publish those list of cargoes that will require coastal shipping permit. And I think they also raised on the issue that how those regulations are made, and there is an established practice in government that before any regulation is made, there's a mechanism of consultations and engaging with those that may be impacted by the proposed regulation, and we then make sure that their views are also taken into consideration. I have addressed, I think in paragraph 14, that the approach that prescribed cargoes will be handled by the minister is in that, because ships move all types of cargoes. It can be liquid bulk cargoes, can be dry cargoes, it can be containerized cargoes, it can be just general transport cargoes, which can be machinery and or the roll-out, roll-in types of cargoes. The approach that we have taken, this is again informed by the consultations that we held, that it's better for this to be approached by a gradual listing of cargoes that would require a coastal permit to be moved in between ports. This we deal with the scare that's been made out there that there would be like a doomsday where South Africa would outlaw any movement of cargoes in between ports by foreign carriers. But the approach that is being taken is a responsible one, where the minister will undertake a process of identifying which cargoes can be moved by local South African companies in between ports. For instance, we are aware that the liquid bulk cargoes in the form of movement of oil in between ports, they've already said they would want to be the priority type of cargo that would wish to participate in this coastal shipping permit arrangement. And this is just one example that if the liquefied cargoes are ready to move in between ports and with the participation of South Africans, it's well and good. So there's already an example where it is possible and it is feasible. The company that presented here, which I'm still going to deal with their comments, Linson Nambi, is one such an example where South Africans have managed to build the required capacity to be able to participate in the maritime economy. And this is an example that the country has the required expertise to participate in this. So the minister having exercising her right to prescribe any type of cargoes that can be moved through the coastal shipping permit, therefore I think makes sense in us moving forward in order to avoid the negative perception that's being given out there that there will be a D-Day where international companies will not be able to move cargoes in between ports. So therefore then the cabotage provisions in the bill are very clear and intentional, and that's why, for instance, as part of building that capacity, we have created the specific provisions dealing with assistance to South African ship owners in order to promote the flag. And one of the things that this legislation would help promote is to build the South African Ship Register, which at the moment is actually close to zero, other than the small fishing vessels that ply the trade in that subsector. But the vessels that we have on the register, they may either be having double flag in that they would, as when they sail outside South Africa, they would not necessarily be using a South African flag. They will be using a different flag, but as they come in, then they use their different flag. It may be very interesting to find out as to whether those, how many South Africans work on board the ships that are registered under the South African flag. And this is a very, I think, appropriate test to determine as to whether the present arrangement benefits South Africa or they don't benefit South Africa. But if you have a coastal shipping market, you've got a leveled playing field, because seafarers, for instance, working on coastal shipping vessels would be paid in rands, and the companies that are trading, they will be paying VAT, and they will be buying locally, which is the opposite of what is currently happening. Coastal shipping activities at the present moment carried out by the major shipping companies. They don't pay VAT, they don't employ South Africans, they don't procure locally, but they benefit from the South African economic value chain with no restrictions whatsoever. So really the approach should not be seen as a restricting foreign carriers, but it's more a transformation provision that creates opportunities for South Africans to participate in their maritime economy. And this is just one picture of what currently prevails in the country. Our country our country has mineral resources. Those mineral resources, in terms of their movement, there is no participation whatsoever by South Africans in the movement of those cargoes now destined for markets outside the country. And this bill at least is not dealing with that, but we are dealing with what happens locally here. Because surely, if we are a maritime country, a maritime nation, we cannot be consumers of services. We have to participate, and the coastal shipping provisions gives that opportunity to South Africa, which is rightfully what we should be actively be participating. Once upon a time, we had Submarine, which was a South African company, which participated both locally in the domestic market as well as international. All that it was acquired prior 1994 dispensation, because again there was a fear that the new democracy is coming in to not to be good for shipping, which I think we're now, that policy is being, I think, regretted, because South Africans cannot acquire their qualification as seafarers unless they have to work on board a ship. And which ship are they going to be working on to get the sea time? So they'll have to queue, at the moment they have to queue to participate in foreign ships for them to get sea time. But coastal shipping arrangement gives South Africans that opportunity so that we can create a true maritime nation. At the moment, without the active participation in the shipping market, we can't claim to be a maritime nation in the true meaning of it. And this bill then comes at the time where already we are looking into 2030 to be an international maritime center. And you can't be an international maritime center where you are not participating in the maritime economy. The stake of coastal shipping is very limited compared to the stake of the shipping activities to which benefits out of South Africa. So those provisions then, and on the cabinet provisions, are the key transformation provisions that would once again make South Africa great, in that we would build this shipping portfolio. And building a local shipping portfolio can only beget South Africa to participate globally, where it is used as a training ground for South Africa to then be able to participate in the carriage of the cargoes, mineral resources that go out of the country. So this is very critical for South. But if South Africa decides not to conduct that training domestically, it would not be expected to be able to engage at an international level. Even the small miners in South Africa who mine, they have to queue on the major shipping lines for their cargoes to move outside the country. And this is because there is an absence, there is no participation of South Africans in the maritime economy. And creating this opportunity in the local, in the domestic market, prepares South Africa to be ready to participate vigorously in the maritime value chain, going beyond the borders of South Africa. Coastal shipping also prepares us as a country to make a meaningful input in the Africa Free Trade Area Agreement, where you refer to intra-Africa trade. An intra-Africa trade not supported by transport services, shipping services, is close to nothing. So preparing this capacity and training for South Africans to participate in the domestic shipping market prepares South Africa to be able to participate in and enable the intra-Africa trade into the continent. So this is a critical area that would give to South Africa that opportunity, which is rightfully theirs, because we have a vast maritime economy which is so critical in ensuring that we deal with issues of unemployment, we deal with issues of creating opportunities for our people. And it will also contribute in the decarbonization of the maritime, in the maritime sector. And then moving very swiftly to deal with the I think the permitting provisions. I would not cover them now because I think I will not speak more about them because I think we have articulated quite clearly that the legislation does quite clearly provide for that. Then I move to a matter that I think made the committee to be concerned about, which was raised by COSATU. And this matter relates to the suggested non-involvement of NEDLAC in the processing of the bill. In dealing with this question, I would like to draw the attention of the Honourable Chair and the members that what you find in the bill at present, this bill, is exactly the same to what is found in the present Merchant Shipping Act. More especially the amendments that were introduced in 2013. Remember, 2013, just 2 years before South Africa ratified the Maritime Labour Convention, which is an ILO, International Labour Organization convention. And the lead ministry for that is the Minister of Labour. So that ratification, when it was achieved and the instrument of ratification were presented to the ILO, then the implementing ministry for MLC convention provisions is the Minister of Transport, because then it speaks to the maritime sector. So in 2011, between 2011 and 2012, the department engaged in an intense negotiation at NEDLAC, which then achieved that the current provisions in the Merchant Shipping Act, as it exists today, is informed by that agreement that was reached in 2013. And in this bill, we have not amended that piece that was achieved at NEDLAC, and many of the the provisions in the present bill therefore find their origin in that agreement that was reached at NEDLAC. This you find in page 12, where we then clearly provide for that, and that the 2013 amendments to the Merchant Shipping Act incorporated those, the input that was received at NEDLAC. So in this bill, we have not changed any of that. And therefore, the department considered that consultation that was conducted in 2013, because we are not proposing any changes to it, that consultation is therefore still valid in us providing for this. But we know that there have been changes in the representatives of various formations, including COSATU. Maybe the notes, I think COSATU will have to just go back to the notes, because those reports of NEDLAC are published documents. You can find them on the internet, where the department conducted consultations. We have got documents that went to cabinet that proved that the department did indeed make those consultations. But then COSATU continued to raise some issues on the base applicability of the Basic Conditions of Employment Act, and the department has provided an unambiguous application of both the Basic Conditions of Employment Act and as well as the Labour Relations Act in clauses 78, 79. And there is no ambiguity in how we have provided for this, and members will find this on page 15. The application of the Basic Conditions of Employment is undoubtedly therefore applicable, and will further be strengthened by the subsequent regulations under this part. In terms of Clause 80 and the application of the occupational health and safety legislation to the merchant shipping, the aim of the clause is to regulate applicability and become an empowering provision. So already the incorporation of that provision does give the minister the power to ensure that it is well regulated. The bill provides no less protection to seafarers than those which are already provided in the present Act. As we have indicated, that the peace that was achieved at NEDLEC in 2013 still applies, and because seafarers' rights and conditions of work are governed by the Maritime Labour Convention. And what you find in the Act mirrors what is in the MLC, which South Africa is party to, and the matters relating to the national minimum wage, for instance, because wages are globally benchmarked by companies and agents representing seafarers, the national minimum wage may be too low for workers who are really, most of them paid in foreign currency. That's why issues of wages are then regulated through the mechanism of an agreement between a seafarer and the agent and the company, obviously employing that seafarer. Now, COSATU proposed that the bill be amended to make it explicitly clear that the basic conditions of employment and the that it is covered. I think if that is not well clear, I think there is no harm in making that clear, much clearer. Clause 285 of the bill provides for the appointment of the Department of Labour inspectors, which I think is contrary to what COSATU thought was not the case, but the reality is that it's SAMSA, South African Maritime Safety Authority, who understand shipping, and I think they would, they've for many years relied on the capacity that SAMSA has in terms of conducting compliance by ships as they come into South Africa. COSAT also had raised the issues where they're proposing the amendment of the bill to cite the core responsibility of the Department of Employment and Labour, and I think we clarify that by indicating that in the Act itself, that was already resolved in 2013, and that there are areas of core responsibility between the two ministries. I think then one thing that COSATU had raised as well, I think related to the issue of the suggested problem in their understanding that the beneficiary in the death of a seafarer under the occupational health and safety is not identified in the bill, but the provision of the MLC provides a compulsory insurance to cover issues of death of seafarers working on board ships, and like in all covers, the beneficiary, the nomination of the beneficiary becomes part of that. The issues raised by SARS are less controversial. I think it's where SARS is requesting that we need to ensure that there are officers who are identified in the bill would be given the necessary training, and a cooperation agreement between SARS and the department and SAMSA would be ensured. I'll move then very quickly look and arrive here at clause 36 on page 20, dealing with the comments from Linson Nambi, Banker Services. I think there the motivation, I think the concern, the comments that are from Linson Nambi support particularly the provisions relating to coastal shipping, which we have already dealt with. Moving straight to clause 26 and the recommendation which they have made in terms of the flagging of ships participating in the local coastal shipping arrangements is being raised. And so there would be not much that we would say here. I think their comment was short and to the point where they have expressed their support. By the way, also, Lisa Nambi is also a member of SASOA, so you would have this separation, this division in SASOA, where you've got a very strong presence of foreign ship owners who are also members of SASOA, but you also have domestic ship owners who are also members of SASOA. And the two companies that were here last week, they are also members of SASOA, but they represent the domestic, and that's Linsen Nambi and VUCA Marine. And that's why you could already see the difference. And I think we have learned to accept that we will always have that division between the international and the domestic, where the international would not want you to participate, but then the domestic wanting to engage and participate in the maritime economy. So then moving very quickly, VUCA Marine as well, I think the issues that they've raised, more particular on digitization, are matters that we have noted, and we would, although we have provided partly to that, it may require that we further clarify those matters. Other than how we have provided for coastal shipping, VUCA Marine's view has always been that you don't even have to prescribe the cargoes, you must just declare that local movement of cargoes in between ports must be by South Africans. But I think we've been careful in taking that radical view and being very clear, so that, because we want this to succeed. And the only way of succeeding is to identify what is manageable and moving and introducing those changes. And that is on page 27. Then moving very quickly, the VUCA Marine raises a labor-related issue where they have got concerns with regards to the right of right to strike. And on the right to strike, and again, this is just a demonstration that we've incorporated what is already there which was negotiated at NEDLAC in 2013 by not disturbing that. But the issue of the right to participate, of the right to strike, is an issue that would require some attention. And then they go on to raise the issue of environmental priorities, which I think are very critical in terms of the coastal shipping services, that one of the criteria that can be part of that permitting arrangement would be that the ships participating there must comply with the greenhouse gas emission reduction opportunities that are there, and as well as on the digitization. The maritime sector is digitizing quite rapidly, and they've raised the issue of ensuring that we provide for digitization. So issues of seafarer well-being have been raised, but those issues would be, I know that we are working on the regulations on the marine pollution, on the seafarers, right, in terms of giving effect to MLC, and that is now on page 31 of the document. And in section 16, moving to page 32, I think it's more in that we have incorporated the ship registration as it was, but they are raising some concerns on the issues of the registration of mortgage, that it was never a matter that required it to be registered with the deeds office. On the rights of seafarers as well, they've commented, and we have responded in that these are all MLC provisions which we're already giving effect to. They welcome the issue of coastal shipping as a revival to South Africa's participation in the maritime economy on page 33, and we cannot agree with them more than they have articulated themselves. Moving on to the later submission from the biodiversity law. So members will recall that these comments their intention was to try and incorporate the marine pollution provisions into this act. So in our responses, we've tried to respond to that by ensuring that we must maintain this separation, slight separation, whilst acknowledging that the benefit of a safety culture is a better marine environment. So without incorporating what already is covered in relevant and specific marine pollution laws in the country. Moving to page 37, where I think they've raised the issue of whether the IGC code and as well as the IPC code regulations are part of, when are they going to be finalized? I think I'm happy to say that these regulations form part of the priority list of regulations that we would be finalizing this year. Moving to, we would not deal with the general comments because this is where we're dealing with the question of the National Environmental Management Act, which is already an act of Parliament. It exists, and the suggestion from this body to from the diversity law to incorporate what is already in the NEMA into the merchant shipping. And I think we have responded by explaining the differences and the beauty of having this separated, because even globally, we explain that issues of maritime safety form part of a different convention, and issues of marine pollution prevention also form part of a different convention. And we have dealt with that convention last year when we were incorporating the provisions of Annex 6 and Annex 4 of the marine pollution prevention legislation. And it doesn't help us to incorporate what is already there. I think that basically that's what we say there on page 39. We also have dealt with issues of the definitions that they have raised under Chapter 1 and clarified the matters relating to the cargo. We have actually welcomed their recommended text of the definition of cargo, and we would be able to work with the text that they provided moving forward. And we have as well, I think, dealt with the question they raised with regards to lack of clarity on what is meant by reference to Section 14 dealing with the coastal shipping permitted vessel. And we have clarified this by providing that their comment, I think, contributes in strengthening and providing that clarity, and we'll be able to consider it moving forward. And the definition that they suggested on the commercial vessel, the comment which is part of page 41, the comment was noted, however, not supported, where we considered that the application provision set the tone in terms of the reading of the bill, and therefore do not see value in the requested clarity, because mentioning naval or defense here regarding the suggested inclusion of a new definition of pleasure craft, we drew their attention of the for them to read these definitions together, because when you read them together, then they make, then you are able to find the unity that we are looking for. On dangerous goods, I think it's more definition out past that, because some of the suggestions we have welcomed. Then on marine casualty, where they have recommended that we include severe damage to the environment, or the potential for the severe damage to the environment brought about by a ship or ships, where they are in it recommending that we include that, we have agreed to actually consider that moving forward. On the marine incident, they've raised the issue, which is on page 44, they've raised the issue of defining the marine incident to include issues of environment. But our motivation, I think our response is welcoming that recommendation, and as well as roping in the definition that is found in other legislation, particularly dealing with mobile offshore drilling units, which we have welcomed in moving forward. On offshore installations, we have as well, I think, welcomed that I'm not going to deal, which is found on page 45. And moving straight to the definition of a person, we have welcomed that as it will include the cooperatives which are part of the definition of a person in our legislation. On the shipping acts, we have their submission. We've noted the recommendation as an improvement to what is in the bill, and on the severe damage to the environment, where they have suggested that the definition is reconsidered in terms of how it is applied in the bill and whether it is in fact appropriate. I think our response to the department that disagrees that this definition is unclear, and the suggestion that it could be left out completely would remove the symbiotic relationship between environment and as well as the regulation of safety. Moving to part of ship registration, we'll not go into greater detail on that because I think it is straightforward on the powers of the registrar, and we have regarded that as an improvement. Section 25 on the refusal of registration, I think the suggestion to include issues dealing with environment, I think makes sense to us. We have noted that, and we'll be able to accommodate that if the committee agrees. Access to the information of the registrar, and I think we have as well incorporated that in our understanding, because I think it aligns this with the Protection of Personal Information Act of 2013. Moving to section 66(2) on page 55, where there was a recommendation that clause 66 bracket 2 should be amended to exclude tankers and bunker barges. An additional paragraph added to clause 6, which reads: a coastal shipping permit issued under this part to a tanker of bunker barge shall be valid for a minimum of 5 years. We have disagreed with that and consider 10 years as just enough. Even I think if you get more than 10 years, it helps those that want to invest in acquisition of ships for coastal shipping to have at least a longer time to pay the debt if they have to pay the debt in acquiring that. So we have disagreed with 5 years. We understand that their motivation was mainly on environmental considerations, but 10, I think, is what was consulted and seems to receive favor from those potential investors in the sector. Section 67 on the cancellation of coastal shipping permit. We have regarded the suggestion of incorporating environmental considerations to be an improvement, and we think moving forward it would be add value to incorporate that. On measures to support South African ship ownership, that raised the issue of why the Minister of Mineral and Energy, and or why not the Minister of Tourism. In effect, our approach, our response is that we would add the Minister of it. It would strengthen the bill if we were to include the Ministry of Tourism. The minerals and resources are critical, considering what we have covered earlier on relating to the movement of outside the country of the mineral resources, so that there is that participation there. Coastal shipping, certain section 70, certain vessels to be licensed on page 54. The submission on the licensing. I think we have partly dealt with that and we consider what is being recommended there, which is basically to revise the provision and provide the revised language which is clear. I think we have considered that, and we think it would be an improvement. On the cancellation of licensing, we have welcomed that as a contribution into the bill. On section 98, prohibition of employment of children, they've commented that we need to up the bar that is on page 56 to make sure that that is aligned with the Children's Act, and we have considered that as enhancing the bill, and we would be in consultation with the Department of Justice to work around that. Chapter 4, Part 2, provision of accommodation and health. The recommendation that's made there is an improvement and is welcomed with the motivation provided. This is most topical problem since COVID-19, and I think in the regulations that would be coming up, in effect, we are dealing with those issues because they form part of the Maritime Labour Convention. Section 239, moving quickly, Chairperson. We have noted the comment on safe navigation and avoidance of dangerous situations, and welcomed and further agree that the recommendation to include offences associated with safe navigation and avoidance of dangerous situations to form part of the offences in Table 2 under Section 379, Bracket 2. On the application of Part 12, they've made a submission there, and our observation and the unidentified consequence of this section appears valid, and possibly the solution to it can be by extending the present 241C by adding the following expression, and this is what we are proposing, provided that the cargo so carried is not carried for commercial gain. So that's very important to ensure that any exemption would not be misused, and that Part 12 would then apply if the carriage is commercial. Section 241 on the application of Part 13, this concern is valid and the recommendation of finding a solution to it is acknowledged. The department considers that the problem may be addressed by the addition of the following provision, and we provide that solution in terms of making the International Code for Safe Carriage of Packaged Irradiated Nuclear Fuel, Petroleum, and high-level radioactive waste on board ships as adopted by the IMO Maritime Safety Committee Resolution 8871. And obviously, I think the applicability of the INF Code to all ships falling under this part. SAMSA shall enforce the provision of the INF Code to all ships as prescribed. And then on Section 250 on environmental hazard, we have welcomed as an improvement, and Section 256 on the safety management system. The department does not support this proposed change, as this is a purely safety legislation, and has explained that the environment becomes a beneficiary of a safe culture. This must be provided for in the pollution prevention legislation of what was recommended. That was on the top of page 62. On the additional requirements, we have welcomed the suggestion made by the biodiversity law, and we would support their incorporation if the committee so agrees. Section 269, report on the authority of marine casualty and other accident to and on board ship, submission on the recommendation regarding Section 269. The recommendation is supported in including accident leading to environmental disasters. However, the suggested change to the heading of that section is not supported, and for the reason of avoiding being too prescriptive in the heading. A marine casualty can include all elements, including an environmental damage. So we didn't want to limit what a marine incident could could mean. And also, the department was also not supporting this suggestion, which is also made later on section 269(1)(a) and 269(2) on page 64 of the document. Moving to 271 on limitation of owner's liability, there was a recommendation on incorporating the principle of NEMA in terms of the levels. I think we're bringing to the attention of the committee that the limits are in line with the limitation of liability convention, even though South Africa is not a part to that convention, but the limits as prescribed entered into force in 1986, and which were later amended by the Protocol of 1996, which entered into force in 2004. This is despite, as I've indicated, that although South Africa is not part of the LLMC, but those limits apply. We have applied them in our domestic legislation. Chapter 6, Marine Casualty and Marine Incident Investigation on Section 275. The recommendation was that the clause is amended to include reference to a marine casualty or marine incident wherever it currently refers to marine casualty. I think our response was that the department does not support this recommendation as it seeks to challenge why we have SOLAS, as I've indicated, as an international convention, and MAPOL as a marine pollution convention treated separately. And that merchant shipping is primarily about safety of shipping, and we've got the marine pollution legislation which gives meaning to the convention, to MAPOL convention. But as we have indicated throughout our responses on this issue, that the beneficiary in a safe culture is the marine environment in any way. And we also identify that the OPRC bill does have provisions for post-incident evaluation and reporting, and that we don't have to repeat it here, and so that's why I think we will not support that recommendation. On the powers of South African Police Service relating to marine casualty, we do not agree with this recommendation. The department considers the present formulation of the clause as well balanced, because SAMSA does work with the police services, and I think in terms of the applicable legislation, SAMSA officers are given the power to board ships and conduct inspections in collaboration where there is a crime reported with the police service. Section 313 on rehearing of formal inquiry. We welcome and the editorials recommended in section 313 with the insertion of order that the case be reheard, and the deletion of prefix to text A in the opinion of the minister. And we consider this to be good to ensure that we remove the subjectivity that was identified by biodiversity law. And that is on page 68. On marine traffic 323, suppression of illicit traffic and drugs on board ships. The improvement that is suggested there is supported, and it will correctly assist in broadening the scope of the chapter to cover the broadest possible scope of illicit traffic, including the new concept of what is called the dark fleet, which ends up participating in all illicit activities. So this is welcomed. Moving to 342 on the prohibitions in respect of offshore installations. We have welcomed the recommendation that's been made there, and we incorporated as follows: securing the safety of an offshore installation, and in D, preventing damage to any other ship or the cargo thereof, or an offshore installation, because that part was not clear, and I think the recommendation helps in clarifying that. Section 329 on the establishment of aid to navigation, where they've indicated it's not clear and what is meant by safe navigation on offshore installations, on wrecks, on sheltered waters. We have disagreed with this, with the concern raised here, and the main issue here is safe navigation on or around these areas, because these are complex areas that mariners have to be aware of their existence, and in any way they would have been identified in the chart that that would be used for navigation purposes, and it's to avoid these areas and make sure that they do not result in casualties. Chapter 8, offences and penalties. We have considered that the part is fine as drafted, and with regard to whether Section 39 should be included in Section 3612, the response is yes, considering the growing number of cases of improper use of certificates, including fake certificates used by the dark fleet. The penalty fits the crime and serves as a deterrence. The offence in 54.2 must be moved to Chapter 8. We agree. We further agree to move all offences and penalties to Chapter 8 of the bill. Moving to Section 72 on the offences and penalties, the recommendations were particularly in 3643, the recommendation is an improvement, and we would support if the committee agrees to it. Section 386, bribery, read together. Section 392, the alignment with the prevention and combating of corrupt activities at 12 of 2004 is welcomed, and that we would welcome that it is built into this. We also support the comment in Section 408, and as regards to the regulations, 431, general matters regarding safety of life at sea, where I think the recommendation was to as well incorporate the environmental consideration. The department does not support this comment as it can be provided adequately in marine pollution prevention legislation. This is where we consider it not advisable to mix these two pieces of legislation, we do, but where it enhances, we are able to incorporate it. Section 435 on matters regarding management for safe operation of ships to be prescribed. The minister has already this power, and in the marine pollution legislation, this is where there was a recommendation to include the power of the minister to regulate marine pollution prevention, and again, not wanting to mix safety and environment, acknowledging that in safety culture, the marine environment benefits. We disagreed with that view. Section 436 on matters relating to high-speed craft, that is welcome. The department wishes to clarify that all the matters raised here form part of the high-speed craft code, which is part of the codes that will be incorporated as part of the safety convention. We further consider it good that the code be mentioned in the bill as the basis that minister will prescribe matters, and for the code to be published for information by the minister, and that the high-speed craft code, which is one of the codes that will be incorporated as part of the safety of life at the convention, we further consider it good that the code be mentioned in the bill. Section 438, additional safety measures for bulk carriers to be prescribed, where there was again another request to include pollution prevention, and we have provided the response as appropriate and of similar nature to the previous sections. Section 439, matters regarding vessels less than 3 meters in length to be prescribed, where there was a recommendation to add the following paragraph, pollution prevention, and again, those matters we think can be best articulated in the pollution prevention legislation. Matters regarding marine traffic to be prescribed. The department wishes to clarify that all the matters raised here form part of the high-speed craft, and that relates to the noise caused by this by the high-speed craft, and we would then they would be regulated when the regulations are made giving effect to the code. Section 452, International Convention to have force of law in the Republic. We have welcomed the comment made there where there's been a mention that we need to have a revised list to include the codes. There is a question as to why are we not as well incorporating the National Ports Act and other pieces of legislation, and I think we have welcomed those comments under that section. Schedule 3, amendment of Section 14(1) of the Customs and Excise Act. We have welcomed the comment and suggest that the deeming provision be replaced as a requirement provision on the transferring of bunker oil as cargo from ships, as articulated and motivated there. So, Chairperson, I think it ends here. This text is just a report of NEDLAC as we have referred to it. As members can see, it made all the, oh, it's not there, sorry. We added the text which we would make available to the committee, which is a report of NEDLAC pertaining to the 2013 consideration of the amendments to the Merchant Shipping Act of 1951, which incorporated the MLC provisions as we have articulated earlier on. Would make this report available, but it's also available online. And I thank you for your attention. We apologize for being long, but we thought it was important to explain in detail.
So you're saying the NEDLAC input is of when?
The NEDLAC report reports on the decision of NEDLAC pertaining to the Maritime Labour Convention provisions in the Merchant Shipping Act.
When was it submitted?
So it's published already. It was when the department was implementing the Maritime Labour Convention in 2013. So this meeting would have, it was a result of the NEDLAC consideration of the proposal from the Department of the Marine Pollution, of the Merchant Shipping Bill of 2013, which is now law, between the period 2011 September to 2012 September. So this is the report that showed that the committee considered and agreed to the incorporation of the MLC in the Merchant Shipping Act, which is what is in the bill at the moment. And that's why we're explaining that we have not changed what was agreed as far back as 2013.
And you assume that when I agreed with you in 2013 on this aspect, I'll still agree with you in 2025? Yeah, I'll give you opportunity, guys.
Because if we had changes that we wanted to introduce in this bill, the department understands clearly that it cannot introduce them outside of the NEDLAC process.
What I'm saying is that you are amending the shipping bill, right? I'm saying you have certain things that you want to develop in the bill, and you assume the other party has no right to develop what was his position in 2013.
But we are not changing anything, Honorable Chair, there, because it's like if you look at the ship.
I don't know what if you get my point. Maybe we must not have a conversation. I allow members. I'll come on this point. What I was trying to say to you, the fact that I believe on ABC in 2013 doesn't mean in 2025 I'm still stagnant on my beliefs of 2013. So you can't therefore say, now that is a new process, you have started a new process, but the fact that on the aspect of what me and you agreed in 2013, you don't have a right to check with me if I'm still standing where I stood in 2013. You get what I'm saying? Eh?
I get what you're saying, Chair.
Okay.
Thank you.
Honorable members.
No, No, thank you, Chair. Yeah, greetings to the colleagues. I mean, I think you've covered the majority of the issues very well. I'm happy with the majority of the responses, especially in regards to Sasoa and your firm stance in protecting the transformation of the ocean economy. Because I was there when Sasoa was making their submissions, and they sort of wanted to put a strong hand, in particular with section 63 to 68, which really is trying to reserve some, of the participation for South African seafarers. So your firm stance on that is welcomed, and thank you on that, and you are supported regarding that. Now, when it comes to COSATU, I'm not sure if I follow correctly when you say that the Basic Conditions of Employment Act, the Operational Health and Safety. So are you saying that because COSATU was raising a concern that those legislations are sort of watered down here, the BCEA, the OHSA, and others, they've been watered down. So you are saying there's no need to rewrite them in this bill because they're already existing in terms of where they are currently. Because what COSATU was raising as a concern was that these, especially the Basic Condition of Employment Act, as well as the Operational Health and Safety Act, have been ventilated, and where the firm stands are, the department can not then come and have a watered down approach in terms of this bill. So what in your response then you are saying you don't need to rewrite them, but the firm stands in terms of what they are, not that you are watering down them on this bill. Is that what I need to get clarity on that? And then on this issue of NEDLAC, Chair, I think my take is, I hear the response now, but I look at it now as an excuse on your side, because even if the position was that the agreements on NEDLAC in terms of 2012 stood, I would assume that you would still go back to NEDLAC and inform them of the process to say, we've had these agreements, as according to what we agreed on in 2012, as the department, we are not changing anything. Therefore, we are proceeding. So that they do not feel that they were not included or involved in the process. Now you are coming as a reaction, you are responding to say, no, by the way, those agreements stand. We didn't even tell you that we are using the same agreements that we had agreed on. So they were completely in the dark, and I get the frustration from COSATU and all of that. So do you not then take that as something that is valid that's coming from COSATU? Because I hear what the chair is also saying, that they might have wanted to have certain amendments because it's been about 10 years since those agreements had stood. So if you had just gone to them and say, this is what we had agreed on, there are new developments in the merchant shipping bill, but we are moving forward with our NEDLAC agreements, that just stands still, and then let them have those inputs and engagement, I don't think we would be where we are today. But yeah, thank you very much, Chair.
Thank you very much. Ngomban.
Thank you, Honorable Chair. I nearly said good afternoon to you. Forgetting that now we are continuing from the morning. Chair, let me firstly appreciate the manner in which these considerations of the received submissions have been handled. It's been a long and hectic work that has been done in the background, behind curtains. But how it is now presented, it gives us those issues that have been raised particularly by the institutions that requested to submit, to have their late submissions for considerations, and we agreed in our previous meetings. Then the other ones that have been presented today, and the reaction and consideration to say these ones we agree to and these ones we cannot. So for me, Chair, I would say to complement our work, I think we need to identify now if there are some gaps that need further public participation. I remember in one meeting we said we shall look at the coastal provinces as well as Gauteng, as it is the economic hub of the country. But I would suggest that if we go for further public participation and public hearings generally, we need to consider all the provinces. Why I say so? I'm looking at Africa and South Africa, where we stand now. You find that the Nile River is gradually causing a crack in Africa. So we don't know, in 50 years to come, we may be having a big river here, the extension of the Nile, that will need these merchants to ship and ferry people now across the Nile towards the northern parts of Africa, that is to Cairo. So let us consider all the provinces. And mostly because, again, it has been emphasized that the curriculum in our schools should consider the maritime studies. So all the provinces should be in this. Kungenjalo ke sihlalo, I'm really happy with what has been presented. Thank you so much.
Thank you very much. Dr. Msinga, you want to come in?
Thank you, Chairperson. Thank you for the further work that's been done on the bill. SASOA is a huge organization. It's a big organization that sort of represents quite a substantial stakeholding in our marine and merchant shipping environment. They continuously make comments around constitutional issues. I would like to hear from particularly Mrs. Governor how we see them. We've had the reaction from the department, which is accepted. But could you give us some legal positioning and views on that, please? I heard in the comments and reactions now from the department in reference to our coastal shipping concept, that there are similar arrangements in other parts of the world. Europe was referenced as having the short sea shipping concept. Is it wise to have a new concept in the form of coastal shipping, whereas there is a particular international concept already with a particular understanding, a term of reference? Isn't it just easier to adapt what is already in existence, particularly because it's an international environment of a global dimension? Then the issue around phasing in, obviously on the flip side it means phasing out. How would contracts be affected? Because I understand that a lot of this form of trade between harbours of a particular country is done under contract, even long-term contracts. And then also the relationship of these contracts, possible replaced contracts, and the relationship thereof with permits. I think our chairperson covered the net lag issue very well. To me, it is also still disturbing that this bill hasn't been to net lag. The reason, with the 2011-12 is a clever one at best, but it doesn't substitute the necessity of a newly gazetted publication to bypass net lag simply because there's a historic occasion where the bill was passed with them. It's the context is different, the environment is a different one, our economic dynamics have changed, there are new things to consider. It still doesn't land well that this bill hasn't been under scrutiny at net lag. Particularly the presentation of Kusatu focused a lot on improving the conditions for our seafarers and on the recommendations of elements whereby we can increase the conditions for our seafarers. It's not much of a consolation to have a reply that we are not compensating them less. The effort here and the opportunity here is to improve the situation. And to keep it the same isn't necessarily better. I would therefore again ask the department to carefully look at ways and areas where we can improve the conditions for our seafarers. Why shouldn't we be the country where any vessel under a South African flag would be famous for the best treatment of our seafarers, irrespective of who else does what? And I think we should also lead in that way and not just have an attitude of, well, what we're proposing isn't less than what they have. That is not the standard. We should look at areas to improve it, and I think Kusatu made a strong argument around that notion. Thank you, Chairperson. That's all from me.
Thank you very much. Honorable Kubek.
Thank you, Chair. Chair, we welcome the inputs, and I think when we look at these bills, Chair, we need to have a situation or create a situation where we get these bills to speak to the advancement of national interests as much as we possibly can. Because these bills cannot just be compliance bills. They must be strategic. So maybe a bit more consultation needs to be had. I heard the colleague here speaking up that the bill needs, he was talking about shipbuilding capacity and that the bill speaks to that. It does need to speak to that. It needs to be clearer on how to build the ship registry capacity in the country. I'm not sure how to phrase that correctly. But basically, more ships need to be under the South African flag, and if we could possibly speak to that and see what kind of incentives we as a country could have to have more people building or registering their ships in South Africa. The shipbuilding capacity on its own as well maybe needs to be looked into, such that we are able to build ships on our own. The maritime governance and admin of in this bill. We need to look at that as well. The gaps in the regulation in the sector largely lead to what is often referred to as profit shifting, illicit financial flows, and all of those things. So I think with the transportation of minerals and mostly minerals that are leaving the country, if we could do a bit more consultation in that space to try and figure out what we mean when we say that the transportation of minerals leads to illicit financial flows, profit shifting. If we could understand that, then I think we could go a long way. No, it's fine. I think I'll keep it at that. Thank you.
Honorable Montan.
Thanks, Chair. Look, I don't think we should go into detail, Chair. I think that the point today is to note the department's response. The bill is in our hands. The department may agree to certain things. We as a committee may not necessarily agree to them. I think that's the first issue that we need to state. I thought Mr. Ntuli, that one of the major things when these stakeholders submit their comments, both the department and the portfolio committee have a duty, in fact a legal duty for that matter, to demonstrate that we've seriously considered their input, whether we agree with them or not. So today I think, and also it assists the department to also think out of the box on some areas of the bill where these guys would have made some very constructive, the stakeholders have made some constructive input or submissions, because I think it's very important that I think as a committee, we want to draft on the one hand, a bill that on a piece of legislation that is good legislation. Hence, we have the parliamentary legal advisor and the state law advisor to make sure that at the end, we come with a piece of legislation, as lawmakers, we come with a piece of legislation that but at the same time, I think that we need to make sure that beyond I don't want to use the word artificial, but that we've taken deep, we've taken these comments deep, even, and analyzed them and say, what do they mean? Particularly because if you look at what the ship owners are saying, which I think that for me, from where I sit, they're being selective, of course, but that's not the point now. When they say, demonstrate to us that this choice or the choice you've taken is better than the choice that we are putting forward. And we've even tested, particularly where you say you want to grow the industry, you want to empower, you want to achieve all of these things. So my view is that as a committee, we should show that commitment, that we're hearing the stakeholders. We're not just say submit and then just deal with them quickly. I think that is very important. That is very important. And if it means, because these are the South Africans, if they make meaningful input and it's a compelling case supported by evidence, my view is that we need to seriously consider. I'm not saying they should be incorporated, but I think that the committee has got a duty to demonstrate that. So, Chair, I think we have now heard the responses of the department. It's not for us to debate them today, whether they agree, or which ones they've accepted, which ones they haven't accepted. I think now we must now prepare for the stage where we'll engage as a committee with the bill. So it means, therefore, that we need to clean up these things. And I think that when I look at some of the comments, for example, where you deal with marine pollution, you agree, for example, so we don't want to overburden this bill and then you'll cross-examine. But I think in many other areas, we've done the opposite of that. So it will be a principle where we cross, because the bill is too big. You don't even know what is it that is trying to address now, because on the one hand you say, let's domesticate, we hear that, and I think the Constitution enjoins us to follow a particular process when we do that. I understand that part. But then the other side, I think, so if you do that, then why would you tell COSATU that your views, for example, cannot be incorporated in that way? So I think that from a drafting point of view, there must be a consistent principle about how we deal with this, so that where you cross-examine, or rather cross-reference in other things, while sticking to the main core of the bill, so that you don't lose it, as it were. So I think it's, for me, going through some of the bill again, without making a comment at this point, because I think as members, when the bill comes back, you have now factored all of these issues, then we'll have our own opportunity, and that's when we'll decide whether this bill raises fundamentally new issues that will then will make a decision at that time, whether we want to go for further consultations or not. There are two submissions that I thought maybe you didn't deal with, or maybe when I was outside you did. I think that there was an issue about national interest that was raised during the public hearings, and they were raised by two different, I think the other chap was called Andrew. He spoke about that, and I even said to him, you didn't take it to its logical conclusion. So I didn't hear us commenting on what we are saying to be, how do we define national security. And then the other submission was on the coastal side, where it talks about our coastal security. I think these are some of the inputs that were made, which I think that we shouldn't jump and deal with them at the general level. We need to be very specific. Some of the guys have given us supplementary submissions. I think that after the public hearings, we had two organizations. The biodiversity guys gave us additional input, where they were trying to address the principle of environmental sustainability versus development. I think they made their input there. SASOA itself had a further input in respect of that. So I just feel that, I'm not saying that that's the totality of what, but we just need to make sure that our process is one where we've invited people, they've made supplementary, beyond even, because we allowed them to make a supplementary. We even said, if you want to elaborate, they've made those submissions. And I suggest that we are seen to be paying attention to that, and then we move straight to the now the challenge which is facing us, for the committee to start to get into the bill. But we need to make sure that the department has addressed each and every submission satisfactorily, because that is a requirement of a consultative process. So I'm not making comments on the content. I'm just focusing on how we deal with these things moving forward. Thank you.
Thank you very much, and thank you very much for your blows.
Just 10 seconds, Chair. There was an issue regarding, I think it was also raised by COSATU, regarding the minimum wage. So I just want to check. I think you say in your response that the minimum wage are determined by the ship owners, right? And then as a legislative body, we can't impose a South African minimum wage, because that will be sort of disadvantages to the workers, because it will be too low. Is that what I'm trying to understand? Is that you are saying we can't impose a South African minimum wage because that might disadvantage the workers, so that's why you are not putting it there. I just need a comment around that, Chair. Thank you very much.
Yeah, thanks very much. I think colleagues will come in. I'm really troubled, DDG, on this substantive procedural issue of NEDLAC. And I'll tell you why. I want you to understand where I come from. Over time now, the labor movement in the country is decrying the fact that we seem to be on a consistent track of collapsing NEDLAC. And I think it's an outcry that is there, Nicholas. Now, I wouldn't want us, even at a time when the labor movement raised a concern with us that this procedural box has not been ticked. And we are seen as a community to be part of perpetuating the collapsing of Network. I want you to understand where we come from. We understand the justifications that you are trying to make. And had you written that, perhaps you say to us, at a point when we started this process of this new bill, we had then informed NEDLAC in writing that, look, we have resuscitated the merchant shipping bill. It is going to Parliament. The views you had given us in the past have been integrated. It would be giving me some sort of sense to say we are in a comfort space to can proceed. But to the extent that we meet in Parliament, a key stakeholder in NEDLAC says, but I was not consulted on this particular matter. It really troubles me at this particular point. I will want you to speak to what honorable members would have said. All in all, you can hear, we are all happy with the purport and the spirit of the bill at this particular point. But secondly, as honorable members are saying, we may not delve much into the content at this particular point until all points are integrated. But to the extent that we have, for now, sufficiently responded to the concerns that have been raising, gives us comfort that we can then move to other steps. The one thing that, like I would have said, clicks in the back of our mind and trouble us is this issue of NEDLAC and how do we go about and through it in a manner that doesn't either jeopardize the bill, but also on the other side in a manner that doesn't send a message that we are endorsing the collapsing of NEDLAC. Because I think that's the two worlds that we're now finding ourselves caught in. I would give you a space to come in and then you respond, as I'm equally from the chairing point of view, processing what would be the best way of dealing with that particular challenge. Because we can't just dismiss COSATU on the NEDLAC matter to say no somewhere and then it's just close as that. Thank you.
Thank you, Honorable Chair, and thank you for the.
By the way, I must indicate I have my two lawyers here.
Yes.
And probably you have seen at some point I had to call the lawyer to come and my other lawyer is at the back there and the other one is here. She was sitting there. I had to request her to come closer because we are now dealing with the substantive matters. Thank you.
No, thank you very much, Chair. I think we need to clarify that we were giving a historical account of the process we engaged with towards the incorporation of the Maritime Labour Convention into the Merchant Shipping Act. But I think the message that we are getting from the committee is that we may have assumed what we should not have assumed, because even though we are not changing anything, but just confirming and alerting NEDLAC that this is what we are doing, but it's not going to impact on the historical agreement. Are you comfortable with that? I think, as the department, that's a fair expectation that we would like to. This is not even to suggest that. I think the spirit in which we understood the matter raised by COSATU was in that spirit, but we are as well. I think we understand we would not want to be the department that is seen to be participating in the suggested marginalization of NEDLAC, and I think that's a fair point that we would wish we would need to address and correct, because indeed although, like, I think on the question on whether the suggestion of watering down what is already provided is there, and as we have indicated, nothing of that is. But I think by confirming that with NEDLAC, it would have helped us not have the hurdle that we seem to be having at this present moment. Now, there was a view that on the language of coastal shipping and possibly the use of short sea shipping. These words, I think the other word that is interchangeably used, it means the same thing, is coastal shipping, cabotage, and short sea shipping. So it's one of the words that different jurisdictions use. And in the context of South Africa, the policy promotes coastal shipping, and we have aligned the provisions strictly to speak to what the comprehensive maritime transport policy and the language that it uses for us to incorporate that into the bill. Now, then the other question that was raised related to how would the introduction of coastal shipping impact on contracts? Usually, contracts in shipping are not it's procurement of a service. It's procurement of a service where the company procuring the service would consider the price. It's about the price. If the price would be, I think, favorable to the shipper, then the shipper would contract on that. So there is like no regulated mechanism of locking long-term contracts on such transactions. So by introducing that, South Africans would participate in the shipping, in the local shipping market, provides a local solution that would be there to be utilized. But because of the policy dictates in terms of addressing poverty and transformation and creating opportunities for South Africans to participate in the maritime economy, the creation of that opportunity on its own then would contribute in South Africa achieving its national interest in terms of the provision of this service. But also, with the current ongoing geopolitical developments, most countries are considering the whole question of security in the provision of certain strategic services that the country depends on. The contribution of the maritime sector is huge in the national economy, and I think, and as well as the predictions of Operation Pakisa indicated that this is the operations are much bigger than what is currently known, and I think the issue of coastal shipping would then help in growing the contribution of that sector in the national economy. And also, if you consider that without participation or the provision of the coastal shipping service, there would not be orders for new ships to be built. So that impacts on the local shipping building industry, because there are global shipping centers in the world, but those orders are placed by companies that are already moving cargoes. Before you have a ship, you must have cargo. So by creating a dedicated opportunity for coastal shipping for South Africa, that guarantees cargo on which South Africans can then participate in the value chain, which would require the acquisition or building of ships. And I must indicate as well here that it is accepted that in the initial phase of the introduction of coastal shipping service, you would not necessarily have to build a new ship. So you could lease. There are various forms of ownership of ships. So in terms of building towards promoting local built ships, there is a mechanism of ensuring that the service will still be provided by different forms of ownership of the ships. And that also contributes into growing the ship register. Now, there's been a suggestion that the desire must be to improve the services, the conditions of South African seafarers. So at the moment, the majority of South African seafarers, if they are not employed by AMSOL, which is a major employer in the sector, if they are not employed by Linsen Nambi, if they're not employed by Vuga Marine, they work on foreign ships. And by creating another employment opportunity in the form of the domestic of coastal shipping, you are expanding the scope on where South African seafarers can participate. At the moment, I think the department has been accused of promoting the training and development of seafarers, where some of them end up remaining unemployed because there are no ships on where they could work. And coastal shipping would create an opportunity for young South Africans who have acquired their qualification to work. And in terms of, we have addressed the issue of the leveling the playing field, in that the foreign ship owners have an advantage because they don't pay VAT as and when they move cargoes inside the country. They don't contribute in the UIF because they are not employing South Africans. They'll be using the crews that they've brought with them in their voyages. Now, then I'd like to just deal with the matters raised by Honorable Montana as they relate to the other issues that were raised, for instance, on the national interest questions. We would, and as well as the issue of security, we would like to request that we come back on those matters in much more detail, and welcome the desire of the committee to help in crafting a bill that would work, and a bill that would demonstrate that it has given due consideration to the issues raised by stakeholders. At the level of the department and in the drafting stages, we have ensured these with the submission that we refused, and I think it is fair to as well to allow the committee to do that. And I've got the DDG with me. Maybe if there is another question that I've not covered, he could assist, and my colleague on my right. The question on the, I think that was directed to the state law advisors. We would leave that to the state law advisors. I thank you.
Thank you, Chair. Just to re-emphasize the point, and good afternoon, esteemed members. Chair, the portfolio committee is a superior structure. So as a department, we come here for oversight and guidance. If the portfolio committee feels that we need to consult further, particularly the issue that has been raised at length of NETLEC, we will take guidance, and we can assure you, Chair, and the committee that we will be able to go back and consult further as we will take guidance of this committee. Thank you very much.
No, thanks very much. Just for interest's sake, did Transnet comment on this? They did.
Yes, Chair, just to share that we conducted extensive consultations, I think over a period of 4 years. So we had various submissions. We held sessions in all the major provinces where we received input from various quarters.
No, thanks. And thanks once again, colleagues, for such thoughtful responses, and to honorable members also for giving themselves time to go to details on this particular matters. I think that is seriously appreciated, colleagues. I think we might have to move in the manner that says, especially on this neglect matter, that we'll consult ourselves with our legal division to say, when the situation is like this, how best can we reconcile the situation without actually collapsing the bill? For now, in our part, we'll adopt our own program, and then as we are awaiting the input from our colleagues from legal, such that they need to find a legal way of integrating the net-like views into the bill within a frame of the law, without us, in actual fact, delaying the process. We need to balance the two. We need to ensure that we assist the process of the lawmaking to move, but at the same time, we don't want a situation where, at the end of the day, when this law is about to be passed, constitutionally is challenged, and the question is asked, was NEDLEC consulted? Was it expected not to be consulted? Then we fail to pass that litmus constitutional test. Then it means all the efforts we have put into, all the good efforts, all the financial injunction, and every other thing that we have done would have been multiplied by 0. So we may have to balance the two. Part of the choices that we have is to then have all the integrated points that we have where we are, the bill going to NEDLEC for input and coming back, and we proceed. But for now, we'll proceed as though if nothing has happened, as we are consulting with our legal division on what is the best legal and constitutionally sound manner of incorporating NEDLEC views, so that we are not found to be in the wrong. I would imagine that covers, Nicholas, that satisfies both the members and yourself and all of us, so that at the end of the day, like I would have said, and as you would have heard all the members echoing the sentiment, the purport, the spirit, and the intent of this bill must be supported so that we move as speedily as possible. Honorable Unsinga and Honorable Montana are right. We need to integrate all the views, Honorable Nkompane, as you're saying, and Honorable Bloss. We need to ensure that all the views are integrated from both the business side, from both labor side, from society in general, users, bankers, everyone, such that at the end of the day, while we want to effect and implement the transformation agenda that we have, but we must never find ourselves being far from either of the parties that are critical and key role players in terms who are going to be affected by this particular law. Hence, this question that we have asked is the Transnet input. We are asking this as a sequel to the question we have asked to them when we met with them, and they have their own challenges, and we have said to them, we are currently dealing with the merchant shipping bill. What have you given input? And because every time we meet everyone, and Nicholas will remember that we ask a question: what are the legal impediments that we have in your space that as lawmakers we should be alerted to? And or what are the laws that are currently before us going to affect you, and how do you think they are going to affect you, both positively and negatively, so that we become an activist type of a parliament that take decisions that do not negatively impact on the sectors that we actually seek to improve. So I think let's handle it that particular way, colleagues, compatriot, and close it at this particular point with the note that we welcome the inputs that you have made and all that. And then we'll then have to discuss with the members on how do we deal with the second round of input, especially the written submission on the bill. How do we go to the second step before we even go to the public hearing? What to the consultation in provinces? What do we do now with the second step? I want to hear from honorable members, their input there, quick, straight to the point. Like I said, we'll operate as if there's no neglect issue, but we have it at the back of our mind. We are trying to deal it with the legal division. For now, we have completed and ticked this box. Let's go to the next box. Yeah.
Chair, I think you've guided correctly, Chair. Because generally, the responses from the department are really excellent, and they speak to all the issues. And I think it's what Honorable Munsana was saying, that even those that we disagree with, but they will feel that they've been listened, and not even feel, they are being listened, and their responses are taken into account. So besides just the neglect issue, which you have guided in terms of how we're going to deal with that, I don't see why we shouldn't move forward with the bill in terms of then what the next process should be. So for me, Chair, I think your guidance is sufficient, and we can move in that regard. Thank you, Chair.
The suggestion we have now is that we need to call for the written submissions. And after that, so we need to agree on the timeline on the written submissions. Because we had the public hearing, we can now extend and have written submissions. From there was an issue of conducting public hearings in provinces. We may have to agree on whether we cluster these provinces or we go to each and every province. What members must be mindful of: as Parliament, we only be able to conduct this hearing over weekend. So we need to agree on a process from when to when are we going to go to provinces. The two options that we have: first option is to go to all the provinces, mindful of the resources required, the time as a resource required, and the financial resource required. That's the first thing. The second option would be then to agree on the cluster of provinces, allocate time, publicize properly, and agree we are clustering these provinces as follows, maybe into 3 clusters. Then instead of going to 9 provinces, you go to 9 clusters. Because when a constitutional test is called, we must not be seen to have not prioritized others over others, but we should be seen to have consulted almost everyone, afforded everyone a chance. But of course, we can do that within the availability of resources, which is the only limiting clause. But now, as we do that, we need to put a process that is effective, efficient, and economic. So that is why there are those two suggestions that you need to speak to now, and then we suggest on how we move. Your experience, Honorable Munsinga? Montana, you'll come.
Thank you, Chairperson. Chairperson, I propose that we consider future public participation in the 4 coastal provinces. It makes sense to me on the basis of the harbours that might be affected in those provinces. And the test question to me is, who else, other than those that have submitted input, would bring submissions if we do public participation outside of Parliament? In other words, if we do it in provinces or the 4 coastal provinces. And I immediately have no doubt that we would get more submissions. And therefore, it should be considered seriously to then do go out. And I would propose to the 4 coastal provinces and the harbour cities in particular. Thank you, Chair.
Yeah, Honorable Montana.
Chair, I think the point that was made during the hearings was that it was important for us to consult with coastal communities. I think that that's a point that was made during the hearings. But I think that we should move beyond that, even if we don't go to all the provinces, but perhaps we cluster them. I think this bill it impacts on the economy of the country. And I'd assume that even people beyond the immediate communities on the coastlines will be affected by this bill. So we could agree, but do that as clusters, not just limited to consulting only the 4 provinces. I think everyone in the country, if we have one, I mean, most of the services, by the way, or products that get onto the ships, you find them in Gauteng, all the liquid fuels that come through Durban, they drive the economy in Gauteng and other parts of the country. So let's have a cluster structure, Chair, just to meet the requirements that would have consulted beyond the request that was made, which was coastal communities have never had the opportunity to interact with the bill. And I think this is related to, because the bill makes proposition for cabotage. And so I think most of the input were coming from that angle. But let's cluster and go deeper in the country.
Thanks very much. Go back.
Thanks, Chair. I agree with Honorable Montana that yes, do the coastal provinces, but we cannot not include the provinces that are inland, because like Honorable Montana says, you've got products that are coming in from the mines in Mpumalanga, the mines in Limpopo, Northwest. We have to find a way to speak to those people as well, because this directly affects them and it directly affects their businesses as well. Thank you, Chair.
Yeah, you'll be the last on that one, Kopa.
Yeah, Chair, I think maybe for a proposal, a direct proposal for me would be, maybe if we do Gauteng, and then we, as a cluster, then we cluster Limpopo and Northwest. I don't know if that could work. And then we do the 4 coastal provinces. And then which province will remain? Mpumalanga. I don't know, Mpumalanga, we can bring it to which coastal province, or do you have to do it on its own? Because if we do Gauteng, Limpopo and Northwest as a cluster, then we do the 4 coastal provinces. Then I don't know what we can do with Mpumalanga. Or then it will mean 4 + 1, and then 5. So it will be in about 5 cluster meetings, Chair. I don't know if I'm making sense.
So earlier on we talked about the EFF way. So the EFF way,
It's a proposal, Chair.
the EFF way is 4 + 4 is equal to 9.
No, Chair. So it's 4.
Yeah.
I'm saying it's the 4 coastal provinces,
Yeah.
right?
Plus
Then it's the
Gauteng.
1 cluster, which has 3 provinces: Gauteng, Limpopo, and Northwest.
Yeah.
Then now you've got Mpumalanga.
Mpumalanga.
Yes.
So that's 9.
No, so it's it's 4, 5, 6. It will be 6 meetings. That's what I'm saying.
No, you're forgetting the province of the Free State, so that's why, because the
Oh,
four,
yes,
I would
yes.
imagine when we say four, you mean Northern Cape, Western Cape, Eastern Cape,
Cape,
and the province of KwaZulu-Natal.
Yes. So
And
then we
you
can
say
do
you-
that individually.
Then you then say you cluster
Gauteng,
Gauteng,
Northwest, and
Northwest, and
Limpopo.
Limpopo.
Yeah. Or then now you are left with Free State
And that's what I'm saying.
Mpumalanga. Oh, yeah. Then you can see what you do with them in terms of maybe bringing them to one of the coastal, or I don't know.
I don't think it would be a problem to cluster both Free State and Mpumalanga in Gauteng. And then you have the four provinces Honorable Hunsinga suggests of the coastal. Then you then have the bulk of the remaining public hearing coordinated in Gauteng, which is a central point for the inland provinces. So you have the four provinces and the Gauteng cluster, which will include the five provinces. Is that fine?
Agreed, Chair.
Sure. So now you know the maths.
Chair, don't start with me, please.
I think Honorable Kubeka wanted to save you, but his math,
I want to say agreed, Chair, that's it.
well, his maths was correct. His geography was out of the window. Okay. Then we'll then have to do the timetable. We may not do it now. Then we'll do the timetable. Then we'll table it in the next meeting. Is that fine? Okay. Then this matter close this subject now. Are we fine, President?
Yes, Chair, I just want to know for sure that this will go ahead, but will there be another round for written submissions during the constituency period?
Yeah, colleagues, remember I said there are two things. We can extend the written submissions for now. As we are going to the constituency period, we can call for the second set of written submissions, which will be from the 3rd to the 25th of April. In that period, whoever wants to write can still write. When we are done, the tabling period, the public hearings period will then circulate at the time when we are done with clustering it and checking everything, the days that we think can work, and then you'll then be able to input on those particular dates. Is that fine? Thank you, honorable members. Then it means on this aspect, we are closed. Is there anything that's remaining? Yeah. We are done with the bill, colleagues, members of colleagues from the department, from both Cape Town and Pretoria. You can stand released to catch the last flight home.
We're going to be in China on the 22nd, just remember that, when we are dealing with the program. Meetings will be. I WhatsApped you about those issues raised by Mr. Ghana. Chair and Mr.
Colleagues, we can now deal with the last business, and then Valerie will take us through the program, and then you'll see there in the program would have the issues Honorable Ghana that would have raised. We'll try to find how to integrate them in the program and what Honorable Mabena would have raised also in a written submission. We'll see how we integrate them in the, maybe to take members into confidence. Honorable Ghana would have raised two things that they want the minister to speak on. There was an issue of the CEO of SAA, and there was an issue of the flight accident that the Honorable Ghana would have raised that we may have to be taken in confidence about. We'll have to integrate them in this particular program. The Honorable Mabena raised the issue around the passenger agency in relation to the investigations report that are there, that we may have to be taken into confidence about the developments around them. Therefore, we will have to integrate the two into our program so that we see at what stage can the minister come with passenger rail, passenger rail, and when can he come with the South African Airways to deal with those two issues. Honorable Ghana?
Thanks, Chair. So what I would propose is that we've got a full day on the 22nd. The minister is coming. It's listed there that the minister is coming. Then we then have point 3. What we can then add there, it's the, because we chose 4 entities that we deal with, we can have a conversation with the civil aviation insofar as the, because since I wrote to you, there was that other accident at the air show. So there are these two ones. Then, because the minister is already, instead of finding another day, we have a full day. On the 22nd, we're going to have a shift like we have today. So let's use that to get the briefing on the, so that we close it. It's not something that we need to go beyond. We deal with it on the 22nd. We deal with PRASA, and then we deal with what you call SACA on those accidents investigations. Then it will have covered. So then when we come back on the 6th, then we can deal with Transnet.
Deal with the businesses.
Yes. So
Okay.
we deal with Transnet, Sanral, and those other ones there. But then we start with the one so that we dispense of all those 3 issues that
Pending
we
issues,
raised
okay.
on that day. Then we can even invite SAA on that day. Then we know that we have dealt with the airline
Okay.
industry on that day. Yeah.
No, thanks very much. I think, can I get indication that we are agreeing with that proposal, which makes our life easier?
There's
No.
no sitting on the 22nd.
Yeah,
The sitting is on the 23rd.
it's fine. No, thanks very much. So we agree. I take the program as read, isn't it? Because you had it as it is. So the only intervention is in those on the 22nd. From there, the program will flow as is. Is that fine? Yeah, and then Valerie can come in quickly.
Just one issue to raise to the members is about the public hearings, the provincial ones. If the committee goes ahead and it's in that period where there are agenda items for deliberations on the merchant shipping bill, those deliberations will be paused until the committee has finalized the public hearings. So, Chair, my suggestion is for the committee to consider other agenda items for that period. We discussed among support staff of a matter that could be taken up by the committee, and that is to start engagements with the department again on updates on certain of its programs, like the implementation of the BRTs, and then see what time can be used to call the participating cities. That is a suggestion. but we will hear from members for a way forward. Should the committee agree to the program today, just be mindful that we are still waiting for the NA program to be finalized, possibly by Thursday morning. So that will give the committee an indication how much time is actually available for committee business, which days the House will sit. And the committee can then use the opportunity, because it's going to be a very long term, 10 weeks, to, as the committee business evolves throughout the second term, update its program as urgent matters may come up. So that is it for now.
That's loud and clear. Honorable Nsinga, then Honorable Muthan.
Thank you, Chairperson. It makes sense what our committee secretary proposes. I also want to reflect on the session which we had this morning, with the emphasis not on the content but of the importance of joint committee meetings. There are urgent matters which we need to continue discussion with, for instance, trade and industry, our colleagues in that committee, but there are also other portfolio committees that overlap with transport, which I would really ask you to consider as a priority for, say, the third quarter, not to infringe on what we're considering now. This is fine, and we can accept this. But please, we seriously need to consider engagement with our colleague portfolio committees. I'm thinking of police, for instance. How safe is our new trains? But there are other safety issues as well. We've had court cases where judgments had to be found to force MECs of particular provinces to safeguard bus corridors, just as an example. So, you know, it leaves us open with the responsibility to proactively engage rather than to reactively engage on these things. And there are several other committees as well, which I would argue. And if you would grant us the opportunity, Chairperson, to make submissions of which of these committees or which of these themes, whereas our legacy report speaks to that directly from a historical perspective. But there are urgent matters that probably might prioritize that list, and if you would grant us the opportunity then to make submissions of particular joint committee meetings, it would really be appreciated. Thank you, Chair.
Thanks, Chair. Two things. Shouldn't we consider pushing back the deliberations of the committee to the next term? Because I think when I look at the time that we have, so I think we should make the decision now. The second issue, I support the principle for joint meetings, and I want to propose that we prioritize the PME one, because it's currently dealing with a bill which affects 4 entities here: AXA, Sanral, SAA, and Transnet. So I think that an engagement of that nature would help us in a great deal here.
Yeah, I think when we relook on the plan with colleagues, we'll then have to integrate the two views that we've raised, and then we'll see how then we best load them, and then in principle we can then adopt the program with the note of those further amendments that need to be effected. Is that fine? Okay. If that's fine, can I get a mover? Honorable Kubeka moves. Honorable member, you must second.
Chair, I absolutely second the adoption of this program. Thank you.
Thank you, Honorable Kobe. Oh, I'm told you are an alternate.
Yes, I am, Chair. which is
Okay.
rather discouraging. This is why I can't.
Can full time, second? Honorable Gopan.
On behalf of Imbokodo, I second
Okay.
as a full member.
No, thanks very much. I think we are done with this aspect. What is the next issue? The minutes of the last engagement, ne? There are 2 sets, 3 sets. Yo.
18 February 27 and 11 March.
Should I also consider them as read? Yeah, we still a quorum. Yeah, Honorable Ghana is back. We are 6. It's yourself. We are 7 actually. Yeah, on 1, 2, 3. One, two, three, 4, 5, 6. Yeah. The issue of honorable.
We're a quorum, Chair.
We're a quorum.
Yes, we're a
Okay.
quorum.
Okay. Okay. Thanks. If we are a quorum, we
And
can.
Honorable Kove assumes the full membership. Yeah, because she represents the smaller parties, so she assumes full membership. As a whip of small parties, I saw
You
prescribed.
so designate.
I saw prescribed, yes.
But apart from honorable Kobe, are we a quorum? Okay. No, thanks. If that's the case, I take the sets of minutes as read. Let's take the first set of minutes to go through it without reading. Honorable Koban.
Yes, Chair, minutes of the 18th of February. I was present, Chair, and I've read them. They are the true reflection of our deliberations. I therefore move for adoption.
Seconder. Honorable Montana, you were not there. There was a caucus of MK. I'm joking. Honorable Montana, again, thanks very much. Next set.
27 Feb, meeting with AXA.
Meeting with AXA at OR Tambo International Airport on the refueling of aircrafts. Yeah. You see, when you don't come here, you miss Honorable God. We deal with serious issues here. You're telling her, ne? And can I get a mover there? Mover Honorable Kubeka was there, I remember. Seconder, Honorable Ngombani, you were there or you had apologized?
No, I was there. It's only on the 11th of March when I was absent.
Okay, thank you very much. I know you were there. Adopted, last set. Colleagues, I hope when we say these minutes are read, indeed they are read, ne? Okay. Okay. You must smuggle there that the honorable members agreed to dissolve. Yeah, the 11th of March, the last set. Public hearing on merchant shipping bill. Here we're at, what is that hotel? We're at Cape San. Mover. Honorable Montana moves. Who second? Honorable Gombani, were you not there? You are not there. Honorable Hunsinga, you were there?
I was not there.
Yeah, Honorable Hunsinga was there. Can you second, please? Honorable Ghana?
Second, Chair.
Thank you very much. The 3 sets of minutes have been seconded. Any other thing? It means it's time to go home. There can only be time to go home. I want to thank these colleagues here. I salute and respect your concentration span. It has been a long day. At some stage, I thought you were going to lose it, but you remained. When we're dealing with now the merchant shipping bill, the way it was so long, hey, I thought I was looking at you, listening attentively. I was like, yo, these colleagues are strong. I really appreciate that, honorable members, and I think let's call it a night. We'll meet tomorrow in the sitting of the. We are sitting tomorrow, honorable Ghana. No,
The budget is passing tomorrow, Chair.
is it passing tomorrow?
The budget is passing tomorrow.
You've got numbers, Chair?
We are not sitting tomorrow. The budget is passing.
Chair, you've got numbers, Chair? GNU? You've got numbers?
Don't worry about numbers.
Thank
The
you very
budget is
much.
passing.
Thank you very much. Tomorrow we are sitting. Let's meet on the terrain of the Parliament of the People. The numbers will be determined not here in the portfolio, but in the tent, comrades. 2 o'clock is the day for South Africans are waiting for. Yeah, the day that the Lord would have made for us. Thanks to our lawyers, ne? Please go and think carefully about what we have raised. Where is the other lawyer? My lawyer, the two of you must go and think and advise